Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge, where we discuss all things edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon are receiving early bird access to this episode. You have the opportunity to ask questions and interact with our speaker, and I encourage you to do so. If you have a question, please type it into the comment section below, and we'll be sure to address it. If you happen to be unable to join us live, or if you have somebody you think would be interested in this topic, episodes are released each week following the live broadcast. So be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have the nationally recognized queen of witness preparation, Elizabeth Larrick. Elizabeth runs the Larrick Law Firm out of Austin, Texas, and focuses on representing victims of personal injury. She also provides trial and jury consulting services, as well as the topic we are here to learn about today, preparing our witnesses for testimony. In addition to all of that, she's the dean of the Keenan Trial College's Witness Prep course. We'll put a link to her website, as well as her contact information in the description below, so you can reach out to her directly with any questions after this episode. In our office, witness prep has become one of the most important trial tools we have. So Elizabeth, tell us how you use EDGE techniques to prepare client witnesses for deposition and trial.
Well, awesome, Jenna. I'm so excited to be here. Thank you for the invite. I love talking about witness prep, so I was excited to come on Fridays with Keenan's Cutting Edge to talk about this. So awesome.
Awesome. We're glad to have you.
Yeah. Well, I just want to kind of talk about some things that are really top of mind, I think, for everybody. And that would be Zoom client depositions. I've talked to a lot of folks across the United States to figure out what's everybody doing. We're still doing virtual here, but a lot of people are in person. So I kind of want to talk about where are we at now? How are we doing with our Zoom client depositions? How does that change our prep? What does that add to it? And so kind of jump us off, Jenna, have you had anybody recently run into any Zoom kind of challenges with client depositions?
I don't know that I've had any challenges, but I've absolutely, in Washington, especially in King County and Pierce County, where I mostly practice, we're doing everything via Zoom. So yeah, and I honestly prefer it. So even when kind of old school defense counsel is like, let's go to Montana and depose this witness, I'm like, or I could just do it from my office, right? So we have also been doing witness prep via Zoom, right? So while and I say witness prep, but you in the EDGE kind of vernacular, we're really talking about our clients, right? Is that right, Elizabeth? That's kind of who we're really preparing and spending all this time with, right? And so we try to kind of mirror, if it's going to be in person, we try to see our client in person, prepare them, but via Zoom, we've been doing that. And I feel like I still get that really good connection with my client. I do. I think a lot of people were concerned about losing that because the way we do witness prep in EDGE is a lot about developing a really wonderful relationship with your client. And I think that it's been really, really successful. And I've had a couple, actually, we've had a few long client depositions, taking up all of the hours that the rules allow for, and they've done very, very well. And witness prep has been just as effective via Zoom as it was in person, I think, anyways.
Yeah, absolutely. I was going to say, I think there were a lot of us that had some resistance. I can remember, Amy Gibson and I got on right in, I think, April 2020. We're like, oh my gosh, we have all these concerns. But I think it's just been let's ride the wave, and Zoom is what it is. And so, practice like we play. And so Zoom prep has been, I think, really, really helpful for, I think, scheduling. Because now the scheduling is so much more flexible for clients. Mostly I have a lot less resistance to it because it's okay. So, instead of me coming to spend, 2 days, 4 hours each day, now we can break it up in 3 or 4 days, 1 hour, 2 hour. Mm-hmm. And it's so much more helpful to be able to do it via Zoom. And like you said, we're walking through this template. We're making connections, whether we're face-to-face with somebody or whether we're talking via Zoom. it's there, because we're being heartfelt, we're opening ourselves up, and we're doing that really good job of still actively listening when we walk through getting them ready. So, and the only problems I've run into are people who just don't have the technology, right? So how do we cross that barrier? And, lots of people are super creative, just, FedEx somebody an iPad or Amazon Fire or a Kindle, to make that happen, and then, get it back, or, figure out a way. I mean, I had somebody I was preparing up in Iowa, and she was an elderly lady who had to have her daughter come over and set up the laptop, and that was just part of the prep, was like, hey, let's just get this. If we get this one little piece down and you have a lot of certainty about how it's going to work and feel confident in technology, like that's going to really like put a lot of people at ease. And so I try to tackle that technology, logistics, Zoom piece pretty quickly before we jump into any part of getting people ready.
Absolutely. It's like a dry run for trial too. I mean, even the deposition itself is like, okay, do you have the right lighting? Do you know how to turn your computer on? Can you access the internet? That kind of a thing. So you've got your witness prep, and then you've got that practice stressful situation. Then you're like, you know what? I feel empowered and I'm ready to go for trial from the technological perspective, in addition to everything else, because you've done the whole thing the way the trial is going to be. So I don't know. Are you guys doing virtual trials down there, or are they in person, or what's going on?
It's a total blend down here. My jurisdiction in Austin is pretty much all virtual, though we're kind of trying to get something in person, versus Houston is still doing theirs mostly in person. So Dallas everybody's kind of all over the board, but I think that, when I think about now, like this Zoom piece of like tackling this, it's almost like we are going to talk about what to wear and what your Zoom background looks like. It's like they go like hand in hand. And it's one of those really simple things to give people certainty, like, oh, okay, I can handle that. Like, you need me to rearrange my background? Like, I can handle that. Like, that's a lot easier to talk about than, okay, you're going to get cross-examined for about 3 hours. So it's just one of those things where like now it just goes hand in hand. Like, hey, we have to talk about what's in your background and what you're going to wear, so it just kind of goes hand in hand now. And I think nearly, at least in Texas, everyone still has the option to do a Zoom deposition, whether you agree with it or not. So we're still definitely doing Zoom depositions, and that's what's going to be played to the jury. So you still want that good background and that great lighting, and no kids running through, or like that kind of interruption, I guess, during deposition. But that's one of the things we talk about is like, okay, if you get stuck and you get kicked out, like, don't panic, because it's going to happen, or someone's going to get kicked out, or the patience that you have to kind of pack now with doing Zoom depositions. And that's one of the things that we really talk about is like, you're going to have to be comfortable asking someone to repeat the question if you didn't catch the whole thing. You really have to make sure that the court reporter hears every word that you say, because Zoom will cut you off, and so that's kind of one of those extra pieces of that preparation where we go over. It's just like, okay, like normally if we were in person, this would probably take an hour, but we're on Zoom and we have all these people have to perfectly align with internet and not talking over each other. So it's probably going to take 2 hours or an hour and a half. So I've definitely had depositions via Zoom where the court reporter kicks out and then she can't get back in. It's like, oh gosh. So I always tell people I'm used to it now because we Zoom so much, and people are kind of used to Zoom for, kids doing school. I know a lot of doctors do that. I mean, I think I met with, financial planners do Zoom now. So people are super used to it, but not for that long period of time.
Yeah, sitting there and being interrogated and all the things that can happen, like, that might not happen with a 20-minute meeting with somebody or whatever. We have a question from the audience. Peter Levine from LA asks, do you have the clients purchase lighting, making sure they look okay? How about that the background looks fine? And how do you deal with those logistic issues? Actually, you kind of answered a lot of that, but that's a good question about kind of purchasing the lighting. Like, how do you deal with that?
Yeah. So thanks, Peter, for that question. I generally just work with what people have. Like, I don't really want to stress somebody out with, hey, I need you to order this Amazon light, or I'm going to send you this light. Most of the time it's like, hey, what's the best room in your house, that we can use? If it's your bedroom, okay, that's great. Well, let's let's take the laptop in there right now and show me the best way, where's the lighting at, and, close the blinds. And so we almost do kind of a dry run just to make sure that their setting looks good. I mean, one time we had a client who we were getting ready for trial. It was going to be in person, but this was like the last depot before trial. And so she was in her office. She rearranged the whole background. I mean, she got a laptop right next to the internet connection, like all the perfect things that you want to have done before starting that Zoom deposition. So we definitely walk through all those things. And if they have to wear, if they can't hear, which is kind of a huge concern for a lot of people, like the audio just doesn't work well, like, figure out some kind of headphone system, even if it's the like big, huge, obnoxious ones, like it doesn't matter. We want you to hear the question. That's kind of what sometimes is more important than making sure that the video looks pretty for defense.
Mm-hmm. Yep. Yeah, I've had tech difficulties even with some of this stuff, with whether I don't know if you saw me before we went on, but I have like a window back here, but it's like someday, I live in Washington, so most days it's pretty dark all day, but today it's super bright. And I'm like, how come my face looks so dark? That's really strange. And I was like, oh, let me pull this curtain here. And then it brightens you up. It's just all that stuff that you don't really think about how it affects the way you present. And that I also find like sometimes I sit like this, if I'm sitting. And so to really talk to your client about how they're presenting and that body language, and, it's sometimes moving your hands, if you're down here, it doesn't translate. You kind of got to be up here or whatever it may be. But yeah, there's a lot of discussion about how it appears on film in this little box versus if I could see your whole self. What do you think about, masks is a question that I have. So I have had some people want to wear masks while they're on video, whether it's because there's somebody else in the room or whatever. Do you practice like that? I mean, I feel like that blocks off a lot of facial expressions, but then again, if you're in trial in person and you have to wear a mask, there's a lot of logistics. So have you had any issues with that, and how have you dealt with it?
We haven't had any issues with that. I generally try to say, like, you're going to need to be in a room by yourself. Like, I don't want to be in the room with you either, just to avoid that whole, debacle of, me sitting next to them, whatever. So I always try to get them in their own space. But I recently had a focus group where the deposition happened and the doctor wore a mask. And there was a lot of kickback from the focus group about like him wearing a mask during the deposition, even though it was in person. And this was back before vaccine. And so I was like, oh, wow, they're in person, but there was a lot of kickback. So I was like, okay. So I just try to, let's eliminate that. You get in your own space so that we don't have to like make that decision or be forced into that corner either way of that perception by any juror or a judge or defense lawyer.
Yeah, absolutely. I think it's almost a trust issue, right? Like, what are you hiding if I can't see you? Even though I don't know that we really think through why that person might be making that choice, or just like, that's weird, even though we're so used to seeing it.
Right. People just, that they're going to jump to that conclusion. So let's just, instead of having to walk through it, let's just completely avoid it and take it off the table altogether. And that's really what I try to do. If there's something that's like, oh my gosh, I'm so worried about this, or like, oh, a mask, I'm like, how can we just take that off the table and just be able to avoid that altogether? Because if that's good, but some things, you just got to walk right through and figure out how do we tackle it? It's going to happen. Like, how do we practice and prepare ourselves? And sometimes that's part of us getting ready as a lawyer with comes to, client prep is like, okay, what is an issue that we can maybe sidestep? What's an issue I can put on somebody else's plate? And what is something that like, okay, they have got to tackle this and it needs to be done, really authentic and feel comfortable talking about it and not feel like, oh my gosh, I just got caught, or, because I feel like you can still see that in this facial expressions over Zoom. Like if somebody gets caught, I mean, you guys, you do virtual focus groups. You can tell when you catch somebody when they're not paying attention.
Yeah,
it's like, you can still totally tell like, oh, I just caught you like doing something else. So
yeah, we've had people who I know are watching movies, or I feel like lately we've been really lucky and have had wonderful participants and they've all been good. But yeah, there was this period of time where I know a lot of people were participating because they knew they could make money. And then, but they were also like watching a movie or doing work or other things. And so, yeah, there is a lot more transparency, I think, than what we might have anticipated. We have another question from Peter. He says, how do you prepare multiple plaintiffs? Do you do it separately, together? Do you want to avoid them conforming testimony? How do you handle that?
Yeah, everybody's separate. I've definitely gotten caught trying to do people together to save, cut corners and save time. And it always ends up just coming back to bite you, because you're always going to, like, someone's, whoever maybe the combo is, maybe we got parent child, maybe we got husband, wife, there's always going to be a resistance to have full, like, open conversation with somebody else in the room, because you're talking about some like deep stuff. And so I've learned a long time ago, take it individually, take the time, and that's the thing, is like, you're going to realize everybody doesn't fit into the perfect mold. Like, yes, we've got a great template, but it's flexible for every different kind of personality, different concerns. And it doesn't fit everybody. Like, you can flex it for everybody, I should say. And so don't think, oh, I can just do this, put everybody in one Zoom and take care of everybody. No, you got to do them all separately.
Yeah, that makes sense. I feel like every time I do witness prep with a client, I mean, maybe one section takes a lot longer, or that section for a different person takes like no time at all, because they're like, that doesn't apply to me and whatever. So I think it would be, that makes a lot of sense. I'm trying to think if we have any cases with multiple plaintiffs. We have multiple defendants, but I don't think we have multiple plaintiffs. But interesting. Hey, will you, Liz or Elizabeth, will you please give us like a general overview of kind of some context about what we're talking about here? Because I've heard you say a couple of things: 1, 2 days, 4 out groups of 4 hours. And I think there might be some people in the audience or who stumble across this podcast episode and are like, holy, like, what are you talking about preparing my witness for that long or that many days? Or what are you doing? So can you share us kind of an overview and like maybe what goals you're hoping to achieve through using this more in-depth method?
Sure, absolutely. So, it's like I said, we talked about, it's a template. It's flexible for all kinds of people, but typically what we are doing is we're taking approach to preparing a client for, let's talk about deposition, because I feel like it's the most, it's the thing we do all the time. We all have clients, they all have to go through deposition. So it's something that is always applicable, and not everybody gets to trial and going through that. But for deposition prep, old school style. So let's talk old school for a second, which is the point of view being, you're going to come sit in a room and this person's going to grill you with questions and you have to answer them. And here's my advice: don't say anything, only answer the questions in front of you. Don't volunteer information. Basically just terrifying people. People are already terrified of it. So, flipping the script and taking a different point of view, being like, this is basically your time to tell your story, right? So that is our point of view. And all being like, let's empower you to do that. And let's do it through you, right? So I'm not going to tell you what to say. So how do we do that? Well, we need to really sit down and understand where they're coming from, right? So we spend a lot of time right on the front end, like, hey, what's on your mind? Like, what's on your blackboard? What do you think about this? What do you think is going to happen? Like, just digging through and making sure we have everything that is their concern, their fear, their worry. We really want to get that all on the table, which means we're going to be listening to all that. And then once we have all that out, then we can sit down and basically correct any misconceptions, talk about what's really going to happen, and really set the stage, right? Because a lot of people come in with like full-blown doom and gloom, like, this is going to be the worst thing that's ever happened to me. Like, I hate public speaking. Like, I don't want to do this. Like, sometimes people get a large resistance to it because it's unknown. And also it feels like you're going to be sitting across from a lawyer who's going to be judging you the whole time, which is, nobody likes that. Like, that's not fun. Like, nobody wants to do that. And most of the time people also have a point of view of like, I'm the one who's been hurt. Like, this is my lawsuit. Like, why am I being judged? They're the ones who should be judged. And it's like, totally understand. And a lot of that comes from people get bombarded all day long with how terrible plaintiffs lawyers are, like greedy people, and all those people, plaintiffs in lawsuits are greedy. And look at all these big verdicts. And those are greedy people, and they don't need all that money. And, it's hard to see through that as a plaintiff, as a client, because you're bombarded all day long. And our job, I feel like, in this setting is to really show how they fit in. Like, yeah, but you play a really big piece in you play a big role, but they haven't yet. Like in the lawsuit, you file it, you do discovery, you do all the stuff. Now it's their turn. And we want that to be a good experience and them to embrace that it's their turn. And so once we kind of get through and get them really set up straight with what it is they're doing, how they're going to do an amazing job, then we step into the shoes of, okay, so let's organize your testimony. Let's look at what are they really going to ask you, and let's organize what you got, And so it's basically really sitting down, making really good visual aids about what is their target, what do they want to accomplish, and what's the truth, right? And in doing that, we're really kind of pulling apart and pulling away from the I feels, I believe, and really just getting down to those really, really solid facts that they have. And that's backed up in other places, right? But until we kind of do that, they're going to be stuck in their same story. The story probably heard the whole case. And then the next part is just practice, right? That role play, that hard cross like hard cross exam role play, to make sure that it's sticking. Like, did we do our job as lawyers and get them ready, or are they still struggling? And that was one of the things that, I really wanted to talk about today, Jenna, was really giving maybe some ideas about how to do better at that, because built into this template, I feel like a lot of people say, oh, okay, yeah, well, I role play with my client, and that's one of the things that's not new to me. And it's like, okay, well, but are you doing it well? Like, is the client feeling prepared from that role play? Because if you do it really well, they're going to be terrified, right? Yeah. They're going to understand, like, oh my gosh, like, wow. And they're also going to see, like, I got this, like, I have the answers for these questions. And I also have the power to say that I don't know. And I'm okay with saying that. And, oh, like, that's a trick. And I don't feel sucked into that. Right. So there's a huge empowerment with that role play too. And it's just like, so all those things take time, right? And rushing through it in 2 hours is really not doing justice. And you're probably not listening. So that's why I talk about, in person, setting aside 4 hours on 2 days, in Zoom, or, that's flexible too, if you need to do 3 days. And that's kind of the nice thing is, you can flex it out 3 days. If you got to do 3 days on Zoom, 3 days, 2 hours at a piece, you can be flexible with what you want, what you need to accomplish. And you're also accomplishing our regular stuff, meaning at some point you're going to go through nuts and bolts and talk about, discovery responses, and like, let's go over your injuries, and let's organize like how you want to give stories about your damages. All that's built into there. But wanting to go through that flow of really giving them a good idea about what's going to happen, empower them, handling all the emotions that go through with depositions and the pressure, and then really giving that good practice before going into the easy stuff. Nuts and bolts is easy. Discovery responses, that's easy peasy. Mm-hmm. Those are all records and documents. So that's kind of a broad overview of really what we're talking about when we talk about this framework or this template.
All right. Awesome. And for anybody who's listening, there is a college specifically dedicated to this witness preparation. And so, I highly encourage anybody who's interested to check that out and find out when it's next being offered, because it's really interesting. Though, just as similar to anything else with the Edge, there's a template that Elizabeth has been mentioning, and it takes a lot of the stress of you having to kind of come up with a model on how to do something off of your plate. And it's not like a word by word, this is what you say and this is what you do, because it's going to be molded to whichever client you're preparing, but it gives you an outline, and it gives you kind of your planned goals and kind of where you want to head and what you want to achieve through that preparation. So I'd highly recommend it. I think I took it from Amy Gibson, actually. She taught mine. So she's fantastic too. Okay, so I have a question, and then we'll kind of move into the hard cross thing that you mentioned. And we do have an audience question waiting, but it's kind of funky. So I want to wait till it fits in.
Okay.
Yes, actually. Okay. Actually, this one from Kurt Arbuckle fits in right with what we were just talking about. He's taken the undergrad college, and so he's wondering if you can give an overview of what the differences are of the advanced college, or why would we go to the advanced one as well?
Sure. Yeah. So undergrad witness prep class covers really does a really, really good job of going through the deposition template. I mean, you're going to go through, get the concept, learn the concept, role play the concept. So the class does a really good job of making sure you walk away with not only just this template, but also how to apply it and how to tackle some of the hangups you may run into and role playing through that. The advanced class is the trial template, right? So working and looking at, okay, so deposition is one thing, but once you get to trial, there's a lot more things you kind of need to consider. There's a lot more things that you need to do as the lawyer before stepping into that room to prepare that client. And also, a lot of stuff's going on, right? So you're getting ready for trial. So it really walks you through that template, but also the advanced is more let's take a deeper look at what we're doing and really kind of marinating with it, and how can we then get better at it? How can we fine tune our skill and just look at this in a deeper way?
Okay. That makes sense. I don't even know if I knew that was the distinction. I think I thought it was like witness prep and then witness prep plus, but that's fantastic. Super, super good to know. All right. So my question then is, so we can hire you, right? Elizabeth, you are somebody I could contact and say, hey, will you please help me prepare my client for deposition or for trial? Is that right?
That's right.
Okay. So with that, is it something I can just farm out to you and be like, Elizabeth, please do this with my client. I'll be over here preparing visual aids or something else. Do you involve the lawyer? How does that work?
Well, I'd say there's a couple of different types of folks out there. Some people, and there's nothing wrong with this, that's just not their strong suit, right? So their strong suit may be handling defense or corporate rep. So doing the client prep may not be their thing. And so that's generally where I'll come in and I'll handle all that. And then just, give the client right back to you, and, have conversations. And so that you kind of know what's going to happen. But basically there's that way. And then there's also the way where people want to be really integrated into what's going on. And that's 100% part of it too, as far as hey, let's all get together on Zoom and then kind of have one-on-ones. But yeah, I totally do either way, as far as sometimes people just don't have time, and there's nothing wrong with that. And so we generally have a really solid handoff about how that's going to work, hand them back, or the other way where it's hey, we're going to be integrated. Jenna's going to come in with us and, take notes, and she's going to totally know what's going on, and we're going to work together. And just have you there, or have the lawyer there as well, just listening in. And, I'll have a lot of people that sometimes just want to learn better how to do it. And so they ask me to come in so they can watch me do it and learn at the same time.
Yeah, that makes a lot of sense. I feel like when I do witness prep, it's such an opportunity for me to connect with my client that I would not really know how to fit someone like you in, but I would also at the same time want to fit someone like you in to make sure that I'm doing it correctly. So that's interesting that you have a lot of different ways in which you assist with this process.
Sometimes what I tell people is I'm here to have the difficult conversations that you may not want to have with your client. So a lot of times I don't get invited into the easier ones. It's more the difficult people or the challenging clients, I would say, that just have in it, challenges come in all kinds of varieties. And so sometimes it's difficult for you, as maybe you already are a really close confidant, so that you can't necessarily bring to them this really big flaw that's going on that's going to really be detrimental when it comes to testimony and deposition. And so that's kind of where I get to be the bad guy.
Okay. All right. That makes sense. I like that idea.
Yeah, of course.
Really hard. All right. So let's see. Let me scroll through. We're getting some good questions. Thank you, everybody, for participating today. Let's see. Well, let's dive into some of the hard cross discussion because I have a couple questions that fit really nicely into that discussion. So tell us how you structure that. Do you bring somebody else in? Do you do it yourself? Do you involve the lawyers? How does that really work?
Yeah. So hands down, there really is no excuse not to bring another lawyer in because we have Zoom now, like zero excuse not to have somebody come in. And so, absolutely it is a must. And that's part of the instruction on, especially putting together the role play and doing it really well, is having somebody else come in and being really time efficient with it. Because if I'm going to ask you to come in, Jenna, you don't want it to be loosey-goosey, respectfully, you have time, you got things you got to do. So it's hard sometimes for me to ask hey, Deborah, can you come and, do this for 30 minutes? And it's oh, wow. So let's talk a little about easier ways to set that up so that it makes it easier for everybody involved and the client gets a really good hard cross. So it kind of all starts off with when you do your memo, when you sit down to look at, okay, I'm going to get, let's say Christina ready. And so I go through my lawyer memo. As I do my memo and look at the case, I go ahead and start crafting some hard cross questions, right? And I make them really unique to her situation. Now, there will be other, hard cross questions that you can throw in at any client, right? How's this affected you? Tell me from the top of your head to your bottom of your toe, every, injury that you've got that you're relating to this crash. You've got a couple in the bank that can just be thrown out there. But I go ahead and write those out. What are these real issues? And then especially when I'm writing out, okay, what are the defense targets? I write out questions for that. So I basically kind of have a bank. So when I ask somebody else to come in, I'll basically send them, sometimes I send them the memo, depending how long my memo is, but most of them I send them an email, I send them the bank of questions, and I say, hey, this is, I kid you not, you're going to be asking questions for 24 minutes. We're going to have a little breaks in between, and this is how many looks I want you to give. So in round one, I want you to be really nice. In round two, I need you to be really, really rude. This lawyer is coming in, is going to say objection non-responsive to everything. And then last one, I want you to be just total deadpan. Just ask the question and give no emotion, right? So that way they get 3 rounds, 8 minutes each, different look, different questions, right? And that way, when whoever I'm handing that off to, it could be anybody. It could be somebody in your office, right? But you're basically got to tackle those hard questions because no matter how you give the question, hard question is a hard question. So you get those questions ready and then you I always tell my client, hey, we're going to role play. I'm going to bring Deborah in. This is how we role play. So she's just going to be here with us for just a little bit of time. She's going to hit it real hard and then she's going to leave. And that also puts a lot of relief on whoever's coming in to help because then I just need you to come in and do the damage and leave.
Yeah.
We'll clean up the mess later, unless there's something particular where, and we'll kind of walk about how I use my role play lawyers to really kind of show the client oh, I got you. So typically what I do is I get my phone out and I tell the client, we're going to role play, but this is how we do it. We're going to set the timer for 8 minutes. You can do 10 minutes. That's okay. But I normally just do 8 minutes, and we're going to role play for 8 minutes straight. You cannot break character. We're all going to be in character, but just know as soon as it goes off, we're stopping. We're going to take a break. I do that 8 to 10 minute chunk because that way you take notes and you can also note the questions that they're struggling with, right? Because if you do a 30-minute section, you're going to forget the stuff they struggled on. This is a helpful thing for everybody as far as chunking it down to small pieces. And then, go for that 8 minutes and then we'll just check in. So I always check in with the client first. How you doing? How you feeling? What were questions you didn't like? Yeah. And then if it's a particular client who is struggling with maybe oversharing or a client that struggles with anger, I always will then check in with my role play client and say, with my role play attorney and say, did you get her? What question did you get her on? It's well, yeah. So this is the question that I asked and I got you, it's oh, okay. Because they need to know like what was the trick question. And so that's what, so then we go again, 8 minutes, right? And that way, if we stay on target, my role play lawyer is on Zoom for 30 minutes and then they're gone, right? Then they leave and then we work on, okay, let's go back through that list of questions. Let's talk about that and walk through it. But it really makes it super digestible for the person helping you. It's digestible for you because now you can track questions, and it's digestible for the client because they know, okay, there's an end time to this. My suffering's not going to go on for 30 minutes. And you can do more than three rounds, but this is a system that kind of came up with because I'd have people come in to help, and then they end up staying really long, and I feel terrible, but also they kind of start coaching the client in the wrong way, right? Because you worked hard, you know what you want, where you want the client to go. And sometimes people have the best of intentions, but it just may not match up. So it avoids that whole thing. It really respects everybody's time. And it's hard for someone to say, like, I don't have 30 minutes to give to you. It's like, oh, come on, you have 30 minutes. I'll have all the questions ready for you. Yeah. And sometimes if you have a really difficult client, you can line up 2 different lawyers to do it, or, a different lawyer and then maybe someone in your office. So it tries to make it as flexible, but also, like you're going to be punching that hard cross really, really well for that client. And then you can, soft role play with them if to build more confidence.
Mm-hmm. Mm-hmm. All right. I like that. I like that it's digestible chunks, and there's a finite amount of time, both for your client's well-being and peace of mind, and for the fact that you can tell somebody who's going to come in and help you, this is the period of time that you're going to be here. It's not going to be all day. No, Young G and I do the hard cross for each other's clients. Like we work on all cases together, but usually one person is kind of like lead and the other person might help with strategy. And so the first time that other person meets the client is during witness prep, when we do mock cross or hard cross. And that's, so we will put down all the questions for the other person, but then the other person knows enough about the case that they can fill in anything. They're like, well, let's see, let me go here and here. That might be helpful. So like, for example, if Young G has a really good relationship with a client, she might not see all the blind spots in the case. And so then I'm like, oh, great outline of this hard cross, but I also am going to add in here, here, and here and see where this takes us. And so use your law partner, use your, friend down the hall who practices law or whatever it may be. And just like really help each other out, because this is a very important part of the empowerment aspect of preparing your client for deposition testimony.
We have a lot of people who put an email out on listservs and be like, hey, does somebody have 30 minutes on Wednesday? And somebody's always jumping in, there's another lawyer who works here in Austin, and she's another edge lawyer. And hey, I need your help. We trade off and off. We tried all the time. So.
Oh, that's awesome. Yeah, actually, that's an interesting point, because Young G and I have struggled to find other lawyers who do edge. There are not very many in Washington. We might actually be the only, I don't know. I shouldn't say that. There are some, but there are fewer. And so especially when we were kind of doing a lot of this in person, it was a lot more difficult. But now I can grab, you or Amy or whoever else I feel, I'm friendly with and feel comfortable saying, hey, do a few minutes of your time to assist. And that's super, super helpful. So it's an awesome resource. Okay, so I have a question that kind of goes a little bit hand in hand in this, but it asks about the actual deposition. So H. Lerner asks, what do you do at a Zoom deposition when opposing legal counsel pulls tricks like coaching the deponent through text? Have you had that problem? Do you nip it in the bud early? How do you handle that?
We talking about like if I'm taking a deposition and I can tell, okay. We actually had this discussion on our listserv recently. And one of the things that I always do is I always ask from the very get-go, is anybody else in the room with you? Okay. And I pretty much always make it a stipulation that defense has to also be on camera, right? So I can see everybody. And then I think one of the things we talked about, spot it once you see it. Like, it's kind of like correcting an animal. Like as soon as you see it, you got to jump on it. And then just, point it out. And one of the discussions that they had on the Texas listserv was, okay, who's had this happen? And everyone's like, me. We can see like the person doing this, or, like watching their eyes, or, like if they had their phone out. And so it's just kind of like, once you see it, trust your gut, just call it out and handle it and figure out how you want to handle it. And I think it always, like, there were a variety. Like one of them was that the defense, like it was a younger defendant, and he had his family like trying to tell him what to say, and you could see him like nodding along, and he got confused and just told the truth.
Oh my God.
So yeah. And then of course we have the other opposite, where it's like the defense counsel is like holding up a sign, and they're like, reading it, and you can see the defense lawyer, it's like, oh man. So it really depends on it, but I'm always like, once you have that feeling in your gut and you can see it, like, point it out. But I try to, take as many precautions as you can in the beginning. Are you sitting by yourself? Like, is there anybody near you? Make sure everybody's on camera, that kind of stuff.
Mm-hmm. All right. That's all really, really good advice. I think the only time I've really been concerned about it, we had a medical malpractice case recently, and the defense counsel was sitting right next to the 30B6 witness. And she was answering questions, like she would kind of look to the side, almost as if he were passing her notes. And I was annoyed with myself because I didn't have him on camera. And I thought, I got to learn from this, and, either make a stipulation or be like, you got to be outside the room or whatever it may be. But I asked, and of course they're like, oh, I am offended you would ask that question. Of course I'm not passing notes. And I'm just like, okay, it's on the record that I suspected it. Okay, that's enough. Maybe it'll scare you enough to stop doing it. Okay.
That's right. I mean, that's sometimes all you got to do is just say, thou doth protest too much. Like, exactly. I think I caught you, it's like,
really, why are you so mad? Totally. All right, let's see. We've got a bunch of questions coming in. So and I know that you had another section you wanted to talk about, but some of this might tie into that. Sure. Let's see. Another one from H. Lerner was, how do you deal with stress of trial? What mistakes have you made at trial that you learned from?
Okay, well, of course, I have made mistakes at trial. I have made tons of mistakes at trial. We had a trial right before the pandemic, and oh my goodness, we had lots of things we learned from there. I would say one of them was, I know this sounds like a really simple thing, but we had a really, really inexperienced defense counsel. Like, I think this was maybe her first or second trial. We were also trying a UIM case, which is a little bit tricky in Texas. And so she didn't really know the law. So we had to really, really push the law, but in a very gentle way, because she's first up. And so that was a challenge. And one of the things that she ended up getting by us was because she clearly didn't know the rules of evidence, and we did, is she threw up a bunch of documents that were not exhibits that we had specifically excluded, but she didn't have any, she hadn't produced any exhibits. And so, like rules of evidence 101, like if you see it, you spot it, like object right away before even like letting that out the door. Well, it got out the door. And then of course, that was one of the bigger things. So I kick myself because like, okay, you got to get ready for that. Like, she was inexperienced. Was she doing it on purpose? Absolutely. So no matter how old somebody is or how many years of experience, like, be ready for anybody to bend the rules at any minute. And then of course I've made other mistakes of like asking people the wrong question. One time, this is a really fun one. So I was doing a trial, and it was a chiropractic case in a very conservative venue. I was putting the plaintiff on, and we had redacted the bills, as far as taking like health insurance off and social security, that kind of regular stuff. Well, there was a bill that actually had the lawyer's name on it because the doctor had billed the lawyer. Well, wouldn't you know that's the piece that got in. So she's up on the stand and she's having to walk through her bills. And so I slapped this piece of paper, this exhibit up on the Elmo, and then poof, there goes the jury. And I was like, took a second, looked at it, and there's, they had billed the lawyer. The lawyer's name is front and center. There's like, it feels like there's nothing on that page but the lawyer's name and the doctor's name billing it. And I said, is your lawyer's name on there? What do I do? Like I was like, I'm just gonna say what I think they're thinking, which is like, why is the lawyer's name on there?
Yeah.
And she was completely unprepared for the question. She handled it perfectly. She goes, well, I gotta assume he had to collect all the copies of my record, so that's probably why. And I was like, dang, she's good. She just so naturally was good at it. But yeah, that was one of those things was just like, all right, I could ignore it or I could just tackle it head on. And so I just did. And that was like one of the funnest trials that we had because we just, kind of we didn't wing it, but like weird stuff like that happened. And we just like, I was just like, okay, well, this happened. And all right, jury, like what does the jury think right now? I'm going to ask that question. So, yeah, be flexible and also, jump on the rules. Yeah.
That could have gone, I'm thinking of one example is asking one question too much or the question too far, right? I had a doctor on the stand, a defense medical witness, and I was like, well, she was trying to say that our client had depression before the brain injury. And I had been through the records and I was like, there's no evidence of this anywhere. And so finally I said to her, I don't remember what the question was, but I said, the question too far was, can you show me in the records where it says that? And sure enough, she came up with a record that said that. And I was like, oh my gosh. I was second chair, I think, on that one. So I melted down next to Youngjee and I was like, I'm so sorry. She's sitting there like, oh my God, I was freaking out. So anyways, it happens and you just have to roll with it, do the best you can with it, know that it's going to be okay. And all of that. So great question though.
I think and I will say like what made me feel okay about like slapping that paper up there. It was like, okay. And then I just treat it like it was a focus group. Like, okay, what would a focus group say right there? And, that focus groups have made me feel so much more comfortable in like, because one, you never know what's going to happen in a focus group. Same thing with a jury. Like, you never know what they're going to say, but a focus group, they tell you immediately what they're saying. So I just assume like, all right, I'm just going to treat this like I know exactly what they're thinking, which is, why is that lawyer's name right there?
Yep. That's a really good point too, everybody. I mean, focus groups really help you learn how regular folks think. And that's not only helpful just in preparing for trial and all of that, but for thinking on your feet when something like that happens. So you're like, okay, what have my focus groups said that they wanted to hear from me if this ever came up? And and it doesn't even have to be in focus groups for that case. It could have been a focus group you did for something completely different. You're like, oh yeah, okay, let me see if I can handle this. And I mean, are you going to get it right every time? Probably not. But you at least you're not so freaked out and scared, right? Because you're kind of like, okay, I can handle this.
That's exactly right.
All right. Excuse me. I'm sorry. I had to drink some water. All right. Let's see. We have a few other questions I want to get through here. You also do jury consultation. Do you help with voir dire and jury selection, helping with opening statement, closing an argument and things like that? Kind of like, are you a full service gal or what's the deal?
Real deal. Yeah. Full enchilada plate is what I was like. Texas, we love our Tex-Mex. Okay, so let's say full enchilada plate. Yeah, no, absolutely. I mean, I think one of the things that has been so helpful is jury selection is super important, but I think, trial strategy and having a big overall 30,000 foot view is also key. And so, full stop, do the whole thing, whatever people need help with. But I will say like, that's one of the biggest takeaways that I've had from using the Edge and in my time in my fellowship with Mr. Keenan was like, get the big picture, stick with the big picture. What are the key points here? And then, how do we string that all together? And so I will say that has been one of the biggest takeaways I've had, that seeing the big picture is like such a key point, especially for trial, and echoing things and sticking with the theme and cutting the fat. That's half the battle, I think, sometimes is we think every detail is important. And we know clients that feel the same way. They want every single detail to be so important. And then we are like, stop, that is not important. Mm-hmm. They're not going to know that until you teach them that. And the jury's the same way. Like, if you give them something, where do they need to put it? It's such a, so it's all it's all like a big puzzle to put it together and making sure you're like got all the pieces and you're putting together the right puzzle.
Yeah, that's excellent advice. I tend to be the person who wants to be too detailed. So I have created, outlines and whatever. I'm rebutting every single defense argument, and I am in the weeds, like Don likes to talk about being in the weeds. And I'm like, I'm going to reading the DSM 4 or 5, and I'm pulling out all the, points to cross-examine the defense witnesses. And you put that in front of a focus group and they're like, I don't even know what just happened. And thank goodness for focus groups and adversarial focus groups in particular, because you get to put it out there and find out that was a bad idea before doing it in trial. So.
Absolutely. They don't care. Yeah. That's when I always tell people is like, people are like, what are you going to learn from a focus group? And I said, well, one of the most important things you're going to get is like, what do they really care about? And what do they not? And so if they don't care about it, you just let it go. And sometimes it's hard. We don't want to let it go. We think that that's we feel good with detail. We love detail. I'm the same way. And so that's why I feel like sometimes it's like, okay, like, let's get our big picture here and try to stick with it, and make sure that we're hitting in on those.
That's really, really helpful. All right. And I think it helps too to have somebody like you come in and tell us, remind us what that big picture is, right? And because we're the ones who are getting stuck in the weeds. We're the ones who are wanting to talk about the details, and you can be like, remember, that doesn't matter or whatever. So that's really, really cool.
Well, Jenna, you pointed out a really good thing, which is we start to ignore the blind spots and we can't even see them. And so it's so helpful to have a second set of eyes come in. You and your law partner get to do that. And sometimes even if you have somebody else in your office doing that, you still get so, I call it, like lawyer psychosis. We're just like, this is all we see. And so sometimes having that extra person come in and, we've got the aid of focus groups and like all this stuff to put together and really knowing like, okay, cut the fat, like here's the deal. And like, this is a problem for you. Like, I know you don't think it's a problem, but the jury says it's a problem, that kind of stuff.
Mm-hmm. Yep. Yeah. We actually found out in a recent case that we had a causation issue during mock cross, but it was like during this whole witness preparation thing. And it was like, oh my gosh, how did that slip by? And that's actually not a super uncommon thing. We have had colleagues go to trial and the jury is like, you just didn't connect the dots. And we forget that you have to connect the dots. And so absolutely, really great point. Have somebody else there to point out things, especially somebody as experienced as Elizabeth, who can maybe think of some blind spots that maybe, can get you starting to think about what's going on in your case and that kind of thing. Let's see, what else do we have here? This is so awesome. Again, everybody, thank you for participating. This is really fun to see all your questions. Okay. H. Lerner also says, do you do any other trial prep other than witness prep? I'm so sorry. That was the question you already asked. Okay. H. Lerner also asks, do you have any formal psych training like psychodrama or anything like that?
I don't. Totally respect all the psychodramatists out there, but I don't have any training in that. So I don't even, I don't pretend like I do. So yeah. And I don't have a psychology background or anything like that either.
Just good at what you do. I imagine it also kind of comes with having done it a lot of times.
Yeah, a lot of mistakes, a lot of learning. And, it's when KTI first started with the college, it was like, we thought like, oh, you're going to take it one time and like, that's it. And we had people that were coming back to take it again. And I was like, why are you here again? And they're like, every time I do it, a different light bulb comes on. And it's like, oh, it's so true. Like every time you read that book a second time, a different light is going to come on. You're going to walk away with something a little more, or a different case is going to highlight a different problem. And so, we all are kind of our own experienced psychologists. We help people through the hardest time in their life. Like we become people's personal confidants. Like it's only natural that we learn a little more about like psychology and how people tick. And that's what we're doing with like the jury is 12 miniature psychologists, right? So like we're all practicing psychology on some level. We want to persuade people, so it's definitely part of the craft for sure.
Yep. Absolutely. Kind of whether you want it or not, you become somebody's confidant, they're telling you all this stuff. And whether I tend not to be the most warm and fuzzy person, but you end up really caring about these people and, championing their cause and everything else. It's really, really neat. All right. Joseph Nypaver asks, when in the course of prep, do you cover all too common errors or mistakes in medical records? So let's see, I've done it at the beginning of day 2 before the hard cross section. And he's wondering if that was a mistake or if that's okay, or kind of when you handle that.
Yeah, I mean, I think it just, sometimes we have, thousands of pages of records, and there's lots of mistakes in there. And it's like, oh gosh, like let's give that to them now versus later. Some people, there may be one. And it's like it's not as big of a deal for you. It's not going to be, and sometimes you have like the one fatal mistake, right? Like the checkbox that is absolutely not supposed to be checked and it is horrible for you. Like, I mean, I think, you're putting it at the right spot. What I always say is the technical stuff, right? The discovery responses, the medical record stuff, get through first the misconceptions and set them really up well for what they're going to expect to handle. And then that's just a small issue, right? Then that's an easy thing. Like, oh yeah, that's easy, tackling. So I think it just depends on how many mistakes do you have? Are they absolutely fatal? But yeah, as long as you're taking it after you kind of get them into that good emotional spot, then you're good to go.
All right, that's awesome advice. All right, I want to be selfish and have you take up the last few minutes here with our discussion on some brain injury stuff, which I kind of highlighted for you before we started this whole thing. We have clients with varying levels of brain damage from car crashes, falls, things like that. How do you prepare somebody who has a damaged brain?
We totally did talk about this. And this is a question I get pretty often. And there's so many varieties of TBI, right? Just so many varieties. I mean, one of the things that we talked about before we got on was, how do you help that person that just has no memory? I mean, you spend time with them and then they come back in and they, hey, what are we doing today? Yep. Oh no, like what's going on? And so what I always look at when I'm going to help somebody or my client has TBI is like, what kind are we dealing with here? Because most of the time, by the time you get to deposition, you have a really good idea. If you don't, get a really good idea before you let them go to deposition so you can understand, okay, what level of prep do I really need to give them? Because if I've got somebody who is really no memory, like I probably shouldn't try to waste a lot of his time, her time, my time, because if they don't remember, there really is no, they're not going to commit this to long-term memory. Hard stop. As much as we wish that they would, those are difficult. I think the harder ones is where they have a recognition that they have a memory issue, but they still have some memory. So it's like this weird kind of middle ground where they really want to be here. They really want to do it, but there's still just some missing pieces. I still think that it's not lost to do some witness prep with them, but I don't think you don't have to grill as much. It's really going to be you looking at that person, evaluating them, like how much is too much? Mm-hmm. And is this a person I need to look at providing notes for, providing a timeline for? Like, how do I, in their condition that they're in, if they have a recognition that they've got a brain injury and they're going to have these, great. Well, what's their comfort level? Like, what can I do to help them feel comfortable and feel embrace what's going on? So it's really going to be a high, you being able to evaluate what they need the most. Can they even be prepped? If it's a different kind of TBI where we've just got headaches and that kind of stuff, they can probably go through the regular prep, and it's probably going to stick, but it's really kind of going to be on you, as the lawyer evaluating what kind of injury do they have? Is it going to stick? Is it not? Is it just going to be frustrating for them for me to just constantly be trying to prepare them and them just being like, what do you mean we already talked about this? So you can avoid that kind of conversation or frustration if there's just no memory.
Okay. All right. That's good, because I always felt super guilty. I wasn't giving them the time they deserved if I wasn't going through the whole enchilada. Right. And so I'm happy to hear that there is kind of you can tailor it to what you know that that person can really handle instead of banging your head against the wall and being like, okay, let's go on to the next step. And they don't even remember what you did in the step before.
That's right. Yeah. No, don't feel guilty. Use your best judgment and pare it down where you need to.
All right. Well, thank you so much, Elizabeth, for being here with us today. And thank you for all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. You all did such a great job of participating and giving us wonderful material to talk about today. If you liked today's episode, please click that thumbs up and don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we will be hearing about the Keenan Law Firm's Law Student Closing Argument Competition. We'll hear from the organizers as well as a law student participant about this awesome opportunity. I look forward to learning more about it along with all of you. Have a wonderful weekend, and I'll see you next time.